Your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. Okay. You, he's filed a bunch of motions on your behalf, and okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what.
One right out the gate, we've got a legal reality check. Ever hear of hybrid representation? That's when a defendant tries to be both the lawyer and the client. Yeah, judges hate that. It's like trying to fly a plane while you're sitting in the back yelling instructions at the pilot. Not going to happen.
To be done, but this is not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. Yes, sir. He's been assigned. I don't know. Did you hire him?
No, I was.
Okay, you appointed, and okay, you want to represent yourself. Anytime you want to do that, let me know, and that would be a bad choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been.
Now that was a warning shot. The judge flat out says it never works out well for the defendant. Translation: representing yourself in a murder case is like showing up to a gunfight with a water balloon, a legendary bad decision.
Our experience in this room with 18 and a half years and 600 jury trials, we can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See you. He's a wise man and he's a good lawyer. You got to trust, run it by him. He knows how to do it and what is the best way to represent a defendant. Okay?
Yes.
All right.
Your Honor, if I may, one of the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the
Yes, sir.
briefly,
Yes,
is
sir.
that prior to the charge of murder being filed against him, he was out on bond. There are other cases in his file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond on the murder charge, and he's been in custody since then. He's asking for consideration, possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million, and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. At least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, another the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times, both of the individuals doing that.
Anything you want to add, sir? You need to go?
No, sir. Counsel.
Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime, unless it's multiple murder. Number two, you, according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is, number one, a serious felony. A most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, won't take much. I think the co-defendant is currently set for October. So
Anything can happen in a case. I
think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We've got everything ready. Mr. Marshall was arrested after this, after we received some additional information.
Lacey, I need this set right after the co-defendant's case.
Yes, sir.
Okay, we'll get it. Please
Yeah,
note
I've
it.
got to
And
file real quick and then
All
I'll
right.
get them a date.
anything else on this?
No, Your Honor, we'll be excused
Thank you.
of that.
That is all. Yes.
Maybe look at it again if we're not with.
Yes, sir. And you are Kevin Wayne Turner.
Yes.
In summary, sir, this indictment in 24 CR 1711 states that on or about June 13th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here, sir? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. There is no fine. You do well, you can shorten it to 1/3. 3 1/3. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will,
Yeah.
and because you are guilty? Here, help me out. If you can pass that to him. Did you sign that document, State's Exhibit 1?
Yes, sir.
Did you understand it? Discuss it with Mr. Rennan? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made.
Yes, sir.
Hold on, everybody. I can't hear. Everybody, thank you. You were mentally competent to enter your guilty plea. There is enough evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, please, Judge.
Okay. Let me ask you a couple of things. Criminal history on the defendant?
No, sir, I don't know there is.
This is an agreement for 10 years. You're asking for less?
Yes, Your Honor, I am.
What's state saying?
I don't have a problem with that, Judge,
What
just
do we
based
think?
on the
That was
history.
asked for 3, Judge.
How about 5?
5, the judge.
Because again, once again, it's a third. You can shorten it to a third and got to be longer than a misdemeanor,
I understand.
which
that
is
5
2 years.
If the court were considered 5, that would be very
Okay.
acceptable to us.
All right. If nothing further, I'm going to find, sir, you have pleaded guilty voluntarily.
Yes.
You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea for State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any findings so long as you follow the terms and conditions of probation, which will be for 5 years in length. The probation officer will go over these with you. These are normal and customary. Essentially, most of these, if not all of them, are conditions I have to follow every day.
Yes.
There is no fine here. There is, though, you're going to be ordered to take and pass defensive driving course as a condition of probation. And people kind of laugh about that one. But the two things: number one, it helps you kind of remember in your mind that this is a 4,000-pound missile you're driving around, and it can do a lot of tissue damage if it hits something else or people. So we got to be very careful in the way we operate motor vehicles on public places. Plus, you're going to get a reduction in your insurance by doing this. So, so it's a win for a probationer. Here, please meet with the probation office, and you will begin now. Thank you.
Thank you, Judge.
All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
He does, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here? Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the punishment range is enhanced from not less than 5 to not less than 15 years imprisonment, up to 99 years imprisonment or life imprisonment. Do you understand the punishment range applicable? And I guess as well, a fine up to $10,000 could be assessed, but that's not going to be of consequence in this case, correct?
That's correct.
You understand what you're facing here, sir? Yep, speak out, so that's nice lady can hear you. All right. The agreement's been reached where you would be pleading guilty, sentenced to 45 years imprisonment. Is that your understanding of the agreement?
Yes.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty, sir? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God. Is that true? Yes. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
Sir, I'm going to follow this agreement. If nothing further, I'm going to find you, Joshua Booker, are pleading guilty to this aggravated sexual assault of a child as indicted in 23 CR 1490. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 45 years. Do you understand what has happened today, sir? And you will be given credit for all time that you have served in connection with this offense. Up to now. How old are you?
18, sir.
You're 18.
Yes, sir.
All right. In 24 CR 2392, here's the indictment that the grand jury handed up. It alleges that on or about November 2nd, 2024, in Jefferson County, Texas, you committed the first-degree felony of robbery with the use or exhibition of a firearm. Do you understand what you were charged with? If convicted of this, you are looking at even 18-year-olds, 17-year-olds. You are looking at, if convicted, no less than 5 nor more than 99 years confinement in prison or life in prison.